Good afternoon and welcome. We're going to go ahead and get started if we could. My name is Dean Reuter, and I'm the director of the Federalist Society's practice groups, and I'm pleased to welcome you here today. This is our panel on obstruction of justice. It's brought to you by our criminal law and procedure practice group. We're very excited to have you here today. This is a complex yet ubiquitous term in public corruption cases and daily newspapers, so I think it's very timely that we have this panel. We'll be looking at just exactly what is obstruction of justice and whether it's used properly in prosecutions. To lead our discussion, we're very pleased to welcome our eminently qualified moderator. Thank you in advance, Judge Garland, for doing this for us today. Also a friend of the Federalist Society, I'll venture to say. He's done a lot of these for us. Judge Garland has been on the U.S. Court of Appeals for the District of Columbia Circuit since 1997. Prior to that, he was Principal Associate Deputy Attorney General, and in that position he supervised the Oklahoma City bombing and Unabomb cases. Prior to that, he was Deputy Assistant Attorney General for the Criminal Division of the Department of Justice, where he supervised white-collar crime cases, criminal appeals, and public corruption cases. So he is certainly well qualified to join us here today. So with that introduction, I'll step aside. Judge Garland.
Thanks, Steve. So I'm going to begin with an introduction of our eminent panel. I'm going to start at the far left because George, who's on the far right, will be beginning the discussion. First on the left is Steve Salzberg. Steve's been a professor of law at George Washington University Law School since 1990. Before that, he taught at the University of Virginia Law School from 1972 to 1990. Steve served as the reporter and then as a member of the Advisory Committee on the Federal Rules of Criminal Procedure and as a member of the Advisory Committee on the Rules of Evidence. In 1988 and 1989, he was Deputy Assistant Attorney General in the Criminal Division in the Department of Justice. From 87 to 88, he served as Associate Independent Counsel in the Iran-Contra investigation. Steve is currently the chair of the ABA Criminal Justice Section. To Steve's right is Jonathan Turley. Jonathan is also a professor of law at George Washington, where he also taught since 1990. You see the pattern developing here. In addition to teaching and writing, he served as counsel in numerous high-profile cases over the last 2 decades, representing accused spies, whistleblowers, military personnel, and a wide range of other clients. Since the 1990s, he has worked under contract as the on-air legal analyst for NBC and CBS News and has had over 24 appearances on Meet the Press, ABC This Week, Face the Nation, and Fox Sunday. So if you turn on your TV on Sunday morning, you're going to see Jonathan. Interesting facts about Jonathan. He was ranked as 38th in the top 100 most cited public intellectuals in Judge Richard Posner's recent study. And he was also found to be the second most cited law professor in the country. I don't know who the most cited was, but I'm sure that he or she would not have made as good a panelist. Who was the most cited? You have any idea?
Alan Dershowitz.
It's okay. Next is Mike Madigan. Mike is a senior partner at the Aiken Gump firm. He has had more than 30 years of experience in white-collar crime investigations, congressional and corporate investigations, corporate governance issues, and Washington legislative and political issues. Among others, he's represented the Chief Justice of the New Hampshire Supreme Court in the first impeachment trial in New Hampshire history, as well as the Chief Judge of the U.S. District Court for the District of Columbia before the Judicial Council of the District Circuit. I know who I'm going to call if I get in any trouble. Mike served as chief counsel to the Thompson Committee, the campaign finance investigation. He also served as counsel to the Senate Watergate Committee under the direction of Senator Howard Baker, where he assembled evidence and prepared and examined witnesses during the historic Watergate investigation. Mike was a federal prosecutor in the district from 1969 to 1973. And finally, we have George Terwilliger. George is a senior partner at the White and Case firm in Washington. He represents and has represented financial, healthcare, energy, telecommunications, and industrial companies in government investigations, civil and criminal investigations, and corporate internal investigations. George has served in the Justice Department many times. He was a U.S. Attorney for the District of Vermont under President Ronald Reagan, Deputy Attorney General under President George H.W. Bush. He also served briefly as Acting Attorney General of the United States, and he has 10 years' experience as an AUSA both in the District of Columbia and in Vermont. Highlights of George's federal service include leadership in investigating the BCCI international banking scandal and managing the rescue of federal officers held hostage in a prison takeover. And you can catch him, or at least an actor who looks remarkably like him, in Recount, which is the new HBO movie about the 2000 election. So we will begin with George, who's going to give us a detailed, but he told me brief, summary of the law, and then we'll give his views on the proper role that obstruction of justice charges play in the criminal justice system. The other panelists will follow, each saying whatever they please for about 6 to 8 minutes. I will interrupt with a question whenever I can think of one, and I'm going to try to pit the panelists against each other whenever the opportunity arises, and then we'll leave time for questions at the end. Dean, just be sure you tell me, because it might get so interesting that we forget about the questions. George.
Thank you, Mayor. Thank you. It's nice to be here with all of you today. It's a great turnout on what is a beautiful Washington Thursday afternoon. For those of you, I see some law students here who may be new to the city. It's like this every day, all summer. What my friend Merrick, Judge Garland, did not mention that in the days of BCCI, he was one of the hardworking local prosecutors working on that case. And when Dean introduced him and said, Merrick is extremely well qualified to talk on these matters, he could as easily be a panelist as any one of us from firsthand experience. I am going to try, and I'm not going to give a tutorial on the statute because, one, a certain amount of familiarity is assumed, and number two, we don't have anywhere near enough time for that. And besides, as the judge observed, nobody can figure it out anyway. But what I thought I would do is approach this overview with two general objectives in mind. One is to try and capture from the prosecutor's perspective what they see as the importance and value and utility of the statute. And second, to talk a little bit about how, in fact, it is actually used and what it means to people who may be on the other side of this. I'm especially glad to be here with the panelists who are here today, all of whom are friends, have sometimes been adversaries, or at least people asking difficult, probing questions when I was in government service. I thought I was trying to think of something I could relate to you that really would capture what prosecutors think about this statute. So with the help of my friend Mike Hunnicky, who works with me at White and Case, and some other folks, we pretty quickly alighted on my friend Pat Fitzgerald, who, as you know, was the special prosecutor in the Valerie Plame leak case, who indicted Scooter Libby. And I call Pat my friend because I've known him a long time, and while friends disagree, I represented somebody in that case, and I thought Pat behaved most professionally from my dealings with him in that case. This is what he had to say after, appropriately so, Scooter Libby was indicted about the case and about this statute. I believe these are all accurate quotes. The truth is the engine of our judicial system, and if you compromise the truth, the whole process is lost. We prosecute false statements, obstruction, and perjury cases on a regular basis, all the time. If a truck driver pays a bribe or someone else does something when they go into the grand jury and afterward lies about it, they get indicted all the time. Any notion that anyone might have that there's a different standard for a high official and that this is somehow singling out obstruction of justice and perjury has it upside down. If these facts are true, meaning the facts in the indictment, if we were to walk away from this and not charge obstruction and perjury, we might as well just hand in our job, because our job as part of the criminal justice system is to make sure people tell us the truth. When it's a high-level official and a very sensitive investigation, it is a very, very serious matter that no one should take lightly. Now, our purpose today is not to talk about whether indicting a truck driver for perjury in the grand jury and indicting the sitting chief of staff of the vice president of the United States are completely analogous tasks in the exercise of prosecutorial discretion. But that might make an interesting seminar on its own at some point. And it is, of course, difficult for any of us as an officer of the court or a servant of the law to disagree with the sentiments that Mr. Fitzgerald expressed. I recall on a very personal basis, in more than one case as a prosecutor, having that sense of outrage about what somebody has tried to do, not to someone else, but to the system. And that's really what this is about. I recall, for instance, Bob Mueller, when he was Assistant Attorney General in charge of the Criminal Division and I was the Deputy AG, deciding that we were going to send John Gotti back to the Eastern District of New York to be prosecuted, where he had, just 2 years before, successfully tampered with a jury and been acquitted, despite the fact that the Southern District of New York laid large claim to many of the facts in that case. But when we asked who's prepared to deal with the possible obstruction of justice, it was clear that the Eastern District had a plan. Since we're looking at obstruction of justice, what I'm trying to do here is see what can we learn about enforcement and, to a certain extent, defending or preventing these kinds of charges. One thing to understand, if you have not encountered dealing with prosecutors on obstruction charges, is that the views that Pat Fitzgerald expressed are not outliers. I believe they are truly representative of the way most prosecutors feel about the importance of this statute and the preservation of the criminal justice system that it has a role in securing. The United States Attorney's Manual says obstruction statutes, quote, protect the integrity of proceedings before the federal judiciary, federal executive departments and agencies, and Congress now, as well as individuals connected with those procedures. This is a direct quote from a couple of court cases. The Fifth Circuit has said the statute's designed to protect individuals involved in federal judicial proceedings and to prevent a miscarriage of justice by corrupt methods. The Supreme Court has said the Omnibus Clause, that is Section 1503, serves as a catch-all, prohibiting persons from endeavoring to influence, obstruct, or impede the due administration of justice. I want to consider for just a moment a few of those terms. First of all, endeavoring. That is, these are, of course, terms used in the statute itself. What that means is all you have to do is try. You don't have to succeed in obstructing justice. Merely trying can be a felony. And try to do what? As little, as much as influence. Influence. Another term of action in the statute that can create a felony offense. And influence what? The due administration of justice. Not, a particular proceeding, not necessarily the testimony of the witness, something as broad as endeavoring to influence the due administration of justice will support an obstruction of justice charge. No wonder the Supreme Court accurately calls 1503 a catch-all provision. Obstruction statutes are, in the broadest sense, in fact designed to protect the administration of justice. The Supreme Court has, however, acted to somewhat narrow the reach of that statute by requiring the government to show a nexus between the conduct at issue and some official proceeding, a judicial proceeding or one of the other covered proceedings. And this means that the endeavor must have the natural and probable effect of interfering with that due administration of justice. And the court has also held that a defendant must have knowledge of the obstructed proceeding. If the defendant lacks knowledge that his actions are likely to affect a judicial proceeding, he lacks the requisite intent to obstruct. That is a quote from United States versus Aguiar. Interestingly enough, the defendant in United States versus Aguiar was a sitting federal judge who disclosed a wiretap and then lied about it to FBI agents when he was questioned. And the Supreme Court later upheld the reversal of that conviction. It, of course, doesn't just cover court proceedings. The statute also covers proceedings before departments, agencies, executive agencies, and committees, and now includes the Congress, where the Congress is, quote, operating or conducting a proceeding under its power of inquiry, and it will remain to be seen as that statute is applied, how extensive that coverage may be. The false statement statute has a play in all of this as well, particularly when it comes to Congress. 18 U.S.C. 1001 does not just prohibit false statements, but in fact makes it a felony for anyone who falsifies, conceals, or covers up by any trick, scheme, or device a material fact, or uses any false writing or document knowing that it contains a false material fact. In many instances, this statute would be enough to get someone in trouble before Congress, even if the reach of obstruction were not sufficient. Prior to the Sarbanes-Oxley legislation, which amended the Obstruction of Justice statute, persuading another person to destroy documents was prescribed by 18 U.S.C. 1512b2, which made it a crime to knowingly and corruptly persuade another person with intent to cause a person to withhold documents from or alter documents for use in a covered proceeding. However, the obstruction statute did not expressly, at least, proscribe the act of destroying a document itself. This gap, if it were that, in the coverage of the statute was remedied by Congress shortly after Enron and filled in, and I'll talk about that in just a moment. In that same time frame, in March of 2002, Arthur Andersen was indicted as an entity in Texas for obstruction of justice because it had instructed its employees to follow the firm's document destruction policy regarding certain Enron documents, even after Enron employees had concluded that an SEC investigation, not yet begun, was highly likely. They were indicted under 1512b for allegedly persuading their employees to destroy documents. A few months later, in July of 2002, Sarbanes-Oxley became law and changed the obstruction statute. And while it retained 15b2, under which Arthur Andersen was indicted, it added a new charge that is now 1512 subsection C, that criminalized the act of destroying documents or to make them unavailable or of diminished integrity for an official proceeding. That diminished integrity piece obviously has a great deal of import to documents, as most are today, that are retained electronically. Mike's going to, I believe, talk about the Computer Associates case. Is that right, Mr. Madigan?
Some point today.
Yeah, okay. Well, look, I was given the overview. I mean, if you want to do this, that's fine. Mike's going to talk about the Computer Associates case in which this statute was applied. The provisions, the bottom line is that the provisions added by SOX significantly broadened the reach of the statute. As you know, the Supreme Court later, several years later, reversed the Arthur Andersen conviction. Now, that doesn't have any great import on the statute, except to the extent that the pronouncements of the court there play into the analysis of how far the court, the Supreme Court, will allow prosecutors to go in taking what is a very elastic standard and expanding it. The court said that they reversed the case on the basis of the jury instructions there, which removed from the standard pattern jury instructions the word dishonestly in connection with the destruction of documents or the obstruction of justice. And the court said the jury instructions failed to convey the requisite consciousness of wrongdoing. Indeed, it's striking how little culpabilities the instruction required. Dishonest was no longer necessary to a finding of guilt, and it was enough for the petitioner to simply have impeded the government's fact-finding ability. Impede has broader connotations than subvert or even undermine. This is obviously an important point for consideration of the statute, because I think what the court is saying is, where there is true evidence of a corrupt intent, of the traditional notion of a criminal offense, mens rea, prosecutors can prosecute that. But we're not going to let juries convict people under instructions that basically read that element as a practical matter out of a case. So what does this mean in terms of practical application of the statute? Just a few brief points on that. First, a business or individual need not be a target of investigation in order to fall under the obstruction statute. Time and time again, I think you see businesses attempting to respond to grand jury subpoenas as if they are civil discovery and running the risk of getting into real trouble. Second, businesses can get in trouble under the collective knowledge doctrine, by which the courts will impute to the corporation various pieces of knowledge that employees might have in order to make findings of the requisite knowledge and intent to commit a criminal violation. The first line of defense to these risks is in fact prevention, and that means that if an investigation has begun or is in the offing, there is a need to have procedures in place to preserve and protect records, and a means and a protocol by which the integrity of records, particularly those in electronic form, can be demonstrated. Secondly, and again, I think all of us at this table have seen this occur time and time again, when a lawyer is representing an individual, even if that individual is just a witness, you cannot hazard that witness going in to give even an informal interview to, say, the Tower Commission, for example. Most of you don't know who the Tower Commission was. They investigated Iran-Contra and took informal interviews. And people were later indicted for obstruction and false statements for lying to the Tower Commission. But you can't let somebody go in to a situation like that unless you and your client have reviewed every piece of paper that came before that person in the course of the events in question, or every piece of paper that they wrote, or everything that they have said publicly or non-publicly about it. Because otherwise you run the risk of being contradicted by your own prior statements, which is an obstruction case in the waiting. The second line of defense has to be, and it's a much more difficult row to hoe, frankly, convincing a prosecutor that there was a lack of intent to obstruct or mislead. And that's where the Arthur Anderson case has some value to the defense of these charges, by saying, look, the court has said it's not enough that it happened. You've got to also show that somebody corruptly intended to do this. And the third line of defense is always, well, even if it occurred, no harm, no foul. If there wasn't an actual obstruction, then the case shouldn't be charged. And this is, of course, an appeal to the exercise of the prosecutorial discretion that I spoke about earlier. The difficulty with that, of course, is the language of the statute itself, which says, well, you don't have to succeed, you just have to try. That's my overview of the statute and a few key points about defending them. I'm very anxious to hear fellow panelists, and would be very anxious to hear what's on your mind about this. Thank you.
Well, would it be so that it was as simple as, just never lie, always tell the truth? If the government asks you for documents, give them the documents. When you go in a grand jury, make sure you don't say anything that's not true. When you go before a congressional committee, make sure you don't say anything that's not true. However, unfortunately, it's not that clear and it's not that simple. And what we've seen in the last 10 years or more, but certainly starting in 10 years when we had something called the Holder Memorandum issued in 1999, but followed not to be outdone in the Bush administration with the Corporate Crime Task Force in 2002, and then the Thompson Memorandum in 2003, which fortunately we were able to get revoked recently. Government prosecutions during that 10-year period of time have gone in the corporate arena to an unparalleled level. And there have been over 1,000 prosecutions and convictions of individuals. We've had the Arthur Anderson case that George talked about, obviously the Enron investigation, and many others. And during this period of time, at least in my view, and we will be discussing this amongst the panel, the government prosecutors have become like kids in a candy store, left unsupervised. They've decided and have utilized every means that they could to get to the result that they wanted. Now, clearly, in our history, under our system of justice, nobody in this room would endorse planting drugs on a known drug dealer, because after all, we know he's a drug dealer. We haven't been able to catch him. He's a menace to the community, so we'll just plant some drugs on him and convict him. Nobody would endorse that. The prosecutors have, in these 10 years, used these statutes that George and our panel is going to be talking about, obstruction of justice, in many different phases, the 1001 false statement statute and the perjury statute, and they've used them in broader and broader and broader terms. George mentioned that the statute, the obstruction statute, has the word endeavoring to do this, that, and the other thing. Over this 10-year period, the obstruction statute has been used for things like not only giving but encouraging false testimony, making false statements to government agents, which I'll get to in a minute, and even encouraging a person to assert the Fifth Amendment when no valid reason exists for that person to do it. Now, that in and of itself is a unusual situation, because I have never seen in my 30 years anybody able to articulate why somebody does not have the Fifth Amendment right and the right under our Constitution to take the Fifth Amendment. So you could drive a truck through these various loopholes that have gotten bigger and bigger in the corporate criminal enforcement arena. Let me just take one, or actually two, real-life examples of the things that George was talking about. In this hypothetical case, it begins with a congressional investigation. And as George mentioned, the obstruction statute has been applied to not only to administrative, like IRS and others, but also congressional matters. So a company isn't being investigated by this congressional committee. This is actually based on a real case. And the subject matter that the congressional committee is investigating has to do with the actual business plan of what this company does. It is not changing the books, hiding, misrepresenting records, and things of that nature. So they ask for the witnesses to come. The company decides which witnesses they should be. The company prepares them. The witnesses testify that they did these things. It was the company business plan. There was really nothing wrong with them. It may have been very aggressive. This happened to be a tax case, maybe a little aggressive, but it certainly they didn't believe it was criminal. So lo and behold, the members of Congress who don't always listen to what's being said, and if they do listen to it, don't agree with it in any event, berate the people about how terrible this is, and they refer it for a criminal investigation. Then a criminal investigation begins, and a criminal investigation immediately tells the company, look, we're going to indict you, a la Arthur Anderson. And you had better cut off the attorney's fees for these people so that they're not able to defend themselves, and you better produce them for testimony. And by the way, if they don't appear, if they take the Fifth Amendment, we want to make sure you fire them. Notwithstanding a case called United States versus Garrity, where if you're a federal employee, you cannot be fired for asserting your constitutional rights, such as the Fifth Amendment. In any event, these people come in and are quote, interviewed. And they tell the prosecutors, look, yes, I did X, Y, and Z. Well, you knew that was a fraud. Obviously, you knew it was a fraud. No, I didn't think it was a fraud. Well, the prosecutor believes that perjury was just committed because this thing clearly, in the prosecutor's view, was a fraud. And the person not only didn't say it was a fraud, but refused to elaborate, et cetera, et cetera. So what happens is the employees then are fired and later indicted. And the indictment, lo and behold, charges obstruction of justice, charges false statements, and charges perjury. The people's ability to defend themselves is taken away by the attorney's fees being cut off. Now, since that time, the Department of Justice has had an epiphany of sorts and issued something called the McNulty Memorandum, which actually now prohibits, unless a rare situation that has to be approved by the Deputy Attorney General himself, prohibits the cutting off of attorney's fees. But I wanted to give you a couple of examples to show that these things are not all that clear. In the case I'm talking about, one of the obstruction counts dealt with falsely stating that the documents in the case had been produced, and therefore the person obstructed a investigation, in this case of the IRS. This statute covers any kind of investigation by any almost any government agency that conducts them, Justice Department, grand juries, in this case the IRS. The indictment itself reads that the false statement to the IRS was that this company, quote, had at this time virtually completed its compliances with the summonses, quote, summonses being the summonses for documents. So based on that waffly type of statement, the person is charged with obstruction of justice. And we have cases like the Quattrone case, in which Mr. Quattrone was convicted of obstruction of justice based on a single email, one email. And the email read, quote, and he's sending this to his employees in the firm, that, quote, I'm strongly advising you to follow the internal firm document destruction procedures, unquote. That's it. One email, obstruction of justice. Mr. Quattrone was actually convicted, and his conviction, fortunately, was ultimately reversed. And as we go forward in the panel, we're going to discuss these other cases involving Mr. Libby and Martha Stewart. You know, one of the charges against Martha Stewart was that she had caused her attorney to make a false statement on her behalf. And the issue in all these cases is, well, is it a false statement? I mean, because you, the prosecutor, don't believe it, does that make it a false statement? And most of the prosecutors are going to tell you yes. Now, let me just close with talking about the case that George mentioned, which now I don't remember the name of, the Computer Associates case in New Jersey, which is an important case for the principle that George touched upon, which is you have to be very careful about having your people ever talk to anybody as informally as it is about anything if there is an investigation. The Computer Associates case in New Jersey stands for the proposition that in that case they had an internal investigation being conducted by the company, not by the government, and they were going to give the results of it to the government so that the government wouldn't prosecute the company, which is a common practice that has occurred in this 10 years, where, as I mentioned, the company is threatened and it does almost anything that the government wants it to do, including throwing all of its employees under whatever bus they could find. And in this particular case, the employees are interviewed by the outside lawyers to the company. they make what the government believes to be false statements to them, in that they didn't say that what they did was criminal, and they are then indicted for 1,001 violations on the ground that these lawyers for the company, who half the people that lawyers for the company talk to, half the employees that lawyers for the company talk to, believe that they're their lawyer. In any event, they indict them for false statements made to the lawyers. And unfortunately, the people pleaded guilty in a plea bargain situation, so that case would never has gotten to the higher level. But it is a frightening case, and one that people in our arena are keenly aware of, because once the investigation starts, whether it's a letter from Congress, whether it's an IRS subpoena or document request, whether it's some other agency request, that is when everybody's red light should go on in terms of representation of your client. And if you happen to represent the company, you're faced with a host of issues about whether they should have separate counsel and all of that. So as we move forward here, I would like to focus on, I'm sure the panel will be focused on, these different statutes as arrows that are being used at unparalleled frequency by the prosecutors, and whether there's something that can be done about that. One thing in closing that can be done is that Senator Specter has introduced S-186, which prohibits a lot of, not the use of these statutes, but a lot of the subsidiary means that they've used, such as trying to get the attorney-client privilege waived, trying to ban joint defense agreements, and the like. Thank you.
Thank you very much. First, I want to thank Judge Garland for agreeing to moderate this panel, and also Dean Reuter, who has made great contributions to the city in putting together panels like this, and of course the Federalist Society itself, which continues to really enrich this city in terms of programs of this kind. I'm going to talk to you primarily as a perspective as a criminal defense attorney today, and maybe a little bit as an academic. But most of my views with regard to obstruction comes from representing people primarily in national security cases. But most criminal defense attorneys, as you can already see from George and Mike's comments, take a rather dim view of obstruction from what we've seen, how they've been used. It's good, by the way, to see George here after his movie came out. Although those rumors of a full nude scene were dramatically overstated. And I also want to say that it's a rare privilege to be here with Steve Saltzberg, because we often talk about the same things, and they rarely let two of us from the school appear together. And it's a great pleasure to be here with my colleague, because Steve has been an inspiration to many of us. Obstruction of justice is often viewed by criminal defense attorneys as sort of one of the sirens of mischief for prosecutors. No matter how good you are in a courtroom, it is very hard to defeat an obstruction charge in many cases. There's really 4 charges that you expect, and that's one of the reasons prosecutors tend to pile them on that fit this category. One is obstruction, one's contempt, criminal contempt or civil contempt, conspiracy, and false statements. Now, in national security cases, you can add material support, which is very, very difficult to deal with because the standard is so low. Most anything proves it. The reason these counts are stacked on to indictments is very simple, because the prosecutors know that you cannot sit down with your client and give them any sense of comfort that they can beat the charge. Because no matter how weak the case is, many of these charges come down to a fact determination. I mean, because it takes so very little to charge someone with obstruction, the acts alleged in the indictment or superseding indictment are usually uncontested. What's contested is the intent. So when you go to a judge and you say, "Judge, come on, I mean, look, they've added these things because they can't nail my client on these other counts. And this is just an effort to get him to plead guilty, or it's an effort to count proliferate. But the judge can't do anything. She can't stand there and say, I'm going to toss it out, because at the end of the day, the validity of that count is primarily a question of criminal intent. And no judge before trial is going to say, I just don't think he has intent. So that's what makes these so difficult to deal with, because even though the judge may find or clearly indicate that he or she doesn't think this is a serious count, there's virtually nothing you can do as long as the indictment's stated factual narrative is correct or uncontested, or simply can't be contested until trial. False statements work the same way. I mean, in this city, most defense attorneys have 18 U.S.C. 1001 tattooed across their foreheads because that's what gets our clients in trouble. And in high-profile cases, as many of you know, what usually ends up to be the trial is not the original scandal, but statements made to some investigator that came knocking. So that's how you get Scooter Libby's, and that's how you get many of these cases, is because it's very hard for people to go into an intense interview and not get something wrong. I mean, I think people don't really think about that. Can you imagine being interviewed about something that happened years ago, and to know that if you miss a phone call recollection, or if you miss a trip? I had a client once where he was indicted because he didn't remember going to a Middle Eastern country. He didn't go to it. He had a ticket and decided that he canceled the plans. The government found the ticket. This was years and years ago. He didn't recall because he never went to the country. They still were able to say, well, that's a false statement. You clearly knew about it. It had nothing to do with the other charges, but it was enough to say that's a false statement. It should go to the jury. So imagine where you're sitting now, whether you could do that. Just take an event, any event you can think of 3 years before this date. Add to that the fact that your counsel is telling you if you get anything wrong, they just might indict you. You're looking at a grand jury. So all this is happening in your life. Maybe you've been fired and you're dealing with that. And then you sit down with a field agent and you try to recollect everything. Do you think you wouldn't make a single mistake? Well, you would be surprised at how trivial the mistakes are that end up indicted. Well, why? Well, it's simple. They want you to plead guilty because false statements, obstruction are a roll of the dice. Particularly if they count proliferate, which is very common in this administration. They'll just hit you with dozens and dozens of counts, most of which are just bull. Even if you nail all those counts from the jury, prosecutors know the dynamics of a jury with a long trial is usually that the jury will sit down and try to give the government something. Because most jurors don't want to just say completely no to the government in a case with 200 counts. They have a feeling there must be something there. And so the natural inclination of people to have compromised decisions leads them usually to one of these sirens, because those are the easiest. Because if you take, for example, my client Samuel Arion in Florida, he defeated all the national security counts. Okay? He ended up defeating all the counts. The jury, actually most of the jury wanted to acquit him on everything. They hung on about 8 counts. That's an exception. But in most of these cases, you end up like my other client, Tom Butler. He was the guy involved in the missing plague vials in Texas. And the government hit him with all these national security counts, accused him of suggesting he had given the plague to Al-Qaeda, that Al-Qaeda actually came to Lubbock, Texas to get plague from my client, as opposed to Mozambique, where you can just drive up and they've got drive-through windows where they'll hand you buckets of plague. But the government, despite all the efforts by the government, they lost on all of the national security counts. But they nailed him on what the jurors clearly thought were just minor counts. And that's the problem, is that they'll often nail your client on some obstruction count or some false statement count, not realizing that under sentencing guidelines, they're pushing him to serious jail time. The biggest problem with that is things like criminal contempt. There's no maximum sentence for criminal contempt. You get nailed for criminal contempt, so they use the obstruction standard as a rough guide. But particularly if you're in my field and you have terrorism clients, terrorism enhancement can throw that into literally decades of sentencing. So what are the problems with obstruction? There are a lot. One is that there's just uncertainty. You don't know if you're obstructing because it can be so fluid. A proceeding under the omnibus section, and really 1503 is the main problem here. But the term proceeding under 1503 can be investigative. It's not a real proceeding. So it can be investigative. You can be nailed for influencing an act that works against the administration of justice. It can not just be destruction. It can be diminishing the integrity of documents. As we saw in Quattrone, it can be sending a single email saying, don't forget our destruction policy. Or you've got the case of Conrad Black. In that case, he removed a box of documents from the office, thinking that he said they thought they were private documents not covered, realized they were not after 2 days, brought the box back. He was convicted of obstruction of justice because he removed files from an office that had been subject to a subpoena. So it's great uncertainty for people. It creates a great deal of redundancy. If you take a look at Samuel Arion, the government in those types of cases will hit you sometimes with 3 or 4 of these. Hit you with contempt, hit you with even false statements, hit you with obstruction, covering basically the same acts in a sort of count proliferation. The biggest problem is simply they force pleas. If you sit down with someone who's never been indicted before, someone like Professor Butler, the world's expert in plague, you sit down with a guy like that. He was totally innocent, and a jury in Lubbock, Texas, which had been terrified about the plague, found him not guilty on all of these counts, rejected all the testimony of the FBI agents. That's how weak this case was. I'm talking about a case where the prosecutors could assume they would win with an overwhelming margin. And so you go to a guy like that and you say, we're going to throw you in jail for 25 years. You've got a kid who's 5, another kid that's 10, 2 kids going to college. You're all going to be ruined. Or you can take a plea and we'll send you away for 2 years. Anything to sort of show that we weren't wrong in the original claim. Well, most people will take the plea. Butler did not. He had a lot of courage. Most people, would you take that plea if you're looking at 25 as opposed to 2? That's what obstruction does. It makes it hard for a father or a mother to look at a prosecutor and say, I'm going to fight you and risk never seeing my kids again on such a fluid provision that even my lawyer can't explain to me what a jury may ultimately decide on. The funny thing is it hurts cooperation. All of this abuse of obstruction and perjury and false statements, I can tell you, I routinely tell my clients not to speak to the FBI. I routinely do it, even when I know they're not guilty of anything. I can't trust the government. I can't trust them going in a national security case, talking about what someone said to them at a mosque, because the way that this often happens is your guy is clean. He says what happened with the conversation in some mosque. The government has some cooperating witness that might have a slightly different memory. The standard operating procedure is you get called by the prosecutor and say, your client's going to be indicted for false statements unless he proves to be a major cooperative witness. And so most people say, just don't talk to the government. So they get less. If you take a look at national security cases, sources have dried up in national security cases. I do a lot of work with the Muslim community. When the United States government asks for information, doors close and phones hang up, just because they know so many people who've been threatened with criminal prosecution for even coming voluntarily to the government. And part of that is because a lot of prosecutors prefer to have someone with a gun at their head. It's just neater, because they get to control the witness. And they don't often think about what that does for people who may want to cooperate with them in the future. It also creates perjury traps. And you'll hear in the national security area, you hear a lot about perjury traps. And that is when the government does not succeed in convicting your client, they often set up perjury traps. The best examples of that is my client, Samuel Arion, and the Oshkar case in Chicago, but those are just two cases. In Al-Arion's case, the government lost a major case in Florida, a huge case, and it wasn't my case. I wish I'd take credit for it. It was Bill Moffitt's case. But they defeated one of the most concerted efforts of the United States government, one of the largest terrorism trials they've put on. And the jury not only acquitted him in his defense, but on the few charges that they hung on, they only had 2 holdouts. The rest of the jury wanted to quit on everything. That's how weak the case was. So when he gets released, they come to him and say, look, we can still retry you on those counts, or you could plead to a single count. We don't care what it is. Just plead any count, obstruction, contempt, anything, so that we can show we got something for you, and then we'll let you leave the country after a period of time. And he said, I'll do that. He said, I don't have any money. I'll do that. And so they reached a plea agreement with the government, and at his insistence, he said, I don't want to cooperate in a grand jury against anyone else. I don't want to do what you did to other people. And so he said, take the cooperation out of the agreement, which they did. But because his counsel at the time, and I don't blame them for this, because there was a time when you could trust a handshake deal, because they didn't put in, you don't have to cooperate, they just took out the cooperation provisions, the government immediately hit him with a subpoena to appear in Virginia. And they held him for over a year in civil contempt, and then when we got civil contempt thrown out, or we got the contempt citation reduced, they're now threatening him with criminal contempt. That's exactly what they did to Oshkar. He beat all the terrorism charges in Chicago. They set up a grand jury, and defense attorneys have to tell their clients, you go into the grand jury, they'll charge you with false statements because it's a perjury trap. And so if you go in, you get charged with perjury. If you do not go in, you get charged with criminal contempt and obstruction. And that's what happened with Oshkar. Oshkar beat the terrorism charges. He got 11 years under the obstruction charge and the contempt charge. 11 years. And the government wanted twice that. So the problem we have here is sort of multifold. And part of it, I think, could be resolved by Congress. There's a couple of bills that are pending. Unfortunately, it used to be handled with prosecutorial discretion. We just don't see that anymore. But we need new guidelines with regard to 1503 to stop the redundancy of these charges. And then judges have to do a much better role. And but judges, the problem with judges is with sentencing, that when you combine all of these different provisions, sentencing goes through the roof. Even with concurrent sentencing, it goes way up. And a lot of judges just don't take any action when they see this. They stick close to that range and allow it to be multiplied. You got people, it's like that old story with a judge in Chicago who hit a guy with this huge sentence, and he said, Judge, I'm 50, I just can't do that sentence. And the judge said, well, son, you do the best you can. And that's not enough when the sentence is based on obstruction or contempt. So Congress, the courts, prosecutors have roles to play here, and we all should have an interest in this because of the rule of law. Thank you.
Okay, I'm going to call on Steve, and I hope he's going to be defending obstruction of justice prosecutions. Otherwise, this is going to be not easy to get any argument here.
Well, when Judge Garland called me, and I'd missed a conference call with the rest of the panel, and he said, what's your view on this? And I said, of all the problems we have in American criminal justice, this is not one that is one of our biggest problems. And that is my view on this. I think most of the obstruction of justice cases that are brought are sound cases, and I'm going to talk about a couple of them. I can't talk about Jonathan Turley's cases. I don't know the facts well enough. But I'll tell you my bottom line on a couple of these issues, some of which the panel will agree with and some they won't. But we learned a long time ago, you heard about Mike talking about it, well, I guess the judge talked about his role in Watergate. I mean, what we learned way back was sometimes the cover-up is worse than the crime. And the cover-up is worse than the crime most often when it's a cover-up that involves government officials, people with power, people who think that they can, in fact, be above the law. I mean, when President Clinton lied, which he did, to a grand jury, in my judgment, he was appropriately sanctioned. He was lucky that he wasn't actually impeached because of lying before the grand jury, that he wasn't convicted, I should say. He was impeached. Because lying before a grand jury by anybody, even if you think you're lying about sex as opposed to things that supposedly would matter more, is corrupting. And anything that corrupts the administration of justice ought to be a problem for us all. Think about this for a second. We got today, and we'll have tomorrow, 2.3 million people in jail or prison in the United States. A quarter of the people on earth who are in prison or jail are locked up in the United States of America. Now, that's a problem. In the land of the free, that's not a statistic that anybody ought to feel proud about. The fact of the matter is we got the highest penalties just about in the world for minor crimes. And we lock up people every day and don't even look back on it. For my money, if you want me to get up here and tell you I really feel badly about Scooter Libby, poor guy, got called before a grand jury and lied. At least that's what the jury found. I don't feel badly for him. His sentence has been commuted by the president he served, at the instance of the vice president for whom he was chief of staff. And Martha Stewart, who's gone into even greater wealth and fame and TV publicity, because after she was investigated for insider trading, which, by the way, I don't think should be a crime at all. I think that's a bad crime, but I don't write those laws. When she was asked about what happened, and she didn't tell the truth, and she, according to the jury, and her broker arranged to backdate an order to make it look like it was cast at an earlier time. I don't feel badly for Martha Stewart. I don't feel badly for Congressman Jefferson in the investigation. I don't know. Maybe it's common for you to have $90,000 in your freezer, and you think that that's something that no one should view as suspicious. And when asked about it, you should be free to make up any story you want. Well, I don't think so. I think when members of Congress are corrupt, if that's what happened, they ought to be investigated, and they ought to be prosecuted, and we ought to be glad that somebody's out there policing members of Congress. And we ought to be glad there's a public integrity section of the Department of Justice, which is responsible, fortunately, rarely for investigating a federal judge. That Ninth Circuit case, it's a rare prosecution, and we're proud of that fact, that we don't have to investigate federal judges because it's so rare that anyone creates that kind of suspicion that would justify an investigation. The fact that Barry Bonds is called before a grand jury and is asked about steroids, I don't think Congress should be investigating steroids. But when the federal government's investigating the use of laboratories to deal with controlled substances that are illegal, people who have knowledge, have an obligation to either invoke their privilege against self-incrimination or to tell the truth when they go before a grand jury. If he lied to the grand jury, he ought to be prosecuted. And it doesn't matter who you are, but the people we're talking about are people who have counsel. They have great lawyers who will advise them. They'll tell them when you go before the grand jury, you've got a right to invoke your privilege against self-incrimination. If you have any question, walk out and talk to me. If you have any doubt, invoke your privilege. They'll get great advice. Most of the people that get locked up in America haven't had lawyers like this. And most of them haven't had the kind of defense that the people you should have sympathy for, according to this panel, that they get. I don't think it's a terrible thing, and I don't think it's so vague in the United States when you have lawyers representing you to know what your obligations are. Now, are there problems? Absolutely. If you let me wave a magic wand, I would do several things. Number one, I would put back into law what had been in every circuit before the Supreme Court decided the exculpatory no case. It is unfair. In my judgment, it's unfair for ordinary human beings when confronted by the FBI or any other law enforcement officer to realize that if they come up and ask a question like, anything about drugs, and the person says no, they've now committed a felony. When everybody knows the no is, really, leave me alone. I don't want to talk. You have to go to law school to know that's what you're supposed to say. I don't want to talk to you. Just don't say no if no is untrue. It is a lever that is unfair, and the people who get caught up in it are not the Martha Stewarts and not the people you've been hearing about. They're well advised. They know when they go to talk to an agent what they're supposed to say and what the risks are. It's the ordinary people, the little people who don't have their own private lawyers. They're people we ought to worry about. And we ought to pay a lot of attention to that. That's a bad statute. It's so overbroad and so pernicious that I really think it needs to be changed. And it won't be, of course, because you won't find 3 members of Congress with the guts to stand up there and say, people should be able to say no when asked a question by the government, when no means leave me alone. That statute will remain in effect. It is the most abusive statute in my judgment. It's not 1503. Second, I agree with Jonathan that if you look at our system, this is not about white-collar cases. It's not about obstruction. When you set up a penalty system like ours, which makes it virtually impossible for anybody to go to trial, it's not just obstruction cases. You look at any case. Judge Garland gets these drug cases. People get offers. You're willing to plead guilty to a crime in order to avoid a mandatory minimum sentence. And many people are, even if they went to a trial, they'd have a chance of being acquitted. I served as the Attorney General's representative on the Sentencing Commission. I'm sure when I meet my maker, I'll pay a severe price for that, because the sentencing guidelines and the mandatory minimum sentences in the federal system have driven penalties up where it is true that prosecutors, acting in good faith, by the way, believing they're doing the right thing, make offers that reasonable people cannot turn down. And we need to take another look at penalties. Everybody in this room who's looked at criminal justice knows that we have over-federalized criminal law. We've made federal crimes that shouldn't be federal crimes. We've had the federal government have a heavy hand in a way it shouldn't. And it's not just white-collar cases. It's not white-collar people who are going to prison in record numbers. It's drug defendants and gun cases, and people go away for very, very long times. We do have a problem, I think, and it's a serious problem of the exercise of discretion when it comes to indicting entities. There is no doubt that when the Justice Department chooses to indict an Arthur Anderson or a Milberg Weiss, that it's pointing a gun at that entity and essentially threatening it with extinction. And the exercise of discretion there is supposed to be policed at the highest levels of the Justice Department. It should be. But nonetheless, that kind of threat is often enough to have a company, a law firm or whatever, turn on people who really need to have lawyers and need to have support. And I agree with Mike Madigan, one of the things that has been very healthy is the sort of abandonment of this notion that companies should be especially wary of being indicted if they actually provide lawyers to people who've given their loyal service to the company over years. That's a sign of criminality? No. It's a sign of the kind of basic support that individuals are entitled to. And I think the McNulty memo is a step forward. I don't think it goes far enough. I think the bill that Senator Specter and Senator Leahy have proposed is probably a necessary bill. One of the things that lurks, and we don't like talking about it, and I just want to mention it, is people in some places believe that white-collar defendants can't get a fair trial before a jury. And this is a really interesting phenomenon, right? It used to be that we thought that jurors would never give the poor, the minorities, the benefit of the doubt, that jurors had a bias. And, of course, that was especially easy to believe at a time when we didn't let minorities serve on juries and we had ways of excluding them and exercising peremptory challenges. But now we hear it very often, that juries, it's true, I tend to still believe that juries will do the right thing if people have the courage to go to trial, which is really the issue. Very few people have the stomach to run the risk of the extreme penalties that are associated with trial when they can cop a plea and come across, much better. I'm reminded, by the way, just one of my reasons I think I have faith in juries is years and years ago, there was Iran-Contra, and I not only served as an associate independent counsel, but when I got to the Justice Department, Judge Walsh asked Attorney General Meese whether I would be the person in the department to deal with all classified information issues. And Attorney General Meese asked me if I'd do it. I said I would. I hated Iran-Contra because every other day I'd get a call from Republican senators, asking me why it was I was being abusive to the defendants. And then the next day, George Mitchell's office would call and ask why it was that I wasn't cooperating with Judge Walsh. I mean, it was like being in the middle of, Never Neverland. But I remember one of the things I had to do was go to Judge Walsh, and I had to tell him that he had to drop the large conspiracy cases he was bringing against Judge Walsh for violating the bringing against North and the others for violating the Boland Amendment. That there was no way we could give him the classified information necessary to prosecute those counts, and they were bad counts anyway. And he said to me, well, what's left? And I said, what's left is the rest of your case, And he said, but that's not important. And I said, it is important. I said, because there are accounts in here about corruption. I said, you've charged Colonel North with taking money and taking gratuities for personal benefit. You've charged him with obstruction, that is, trying to destroy documents after the fact. These are serious charges. You may want to talk about Nicaragua and Iran and, hostages in arms, but I said, the commitment of the United States to the rule of law that Jonathan talked about is a commitment that everybody obeys the law and nobody seeks personal advantage in Iran-Contra or anything else. That case was tried to a D.C. jury. That D.C. jury was drawn like all the juries we have here. It was a largely minority jury. It was almost certainly an exclusively Democratic jury. Oliver North was, of course, associated with President Reagan and a Republican administration and a scandal. And that jury here in the district acquitted North on all counts but 3. And the 3 counts were corruption. Obstruction of justice for trying to destroy evidence, taking gratuities, and there was another count. I don't believe that white-collar best advice, and if anybody can ever negotiate with the Department of Justice, they get to negotiate. But I think what we ought to learn from this panel is that penalties are too high across the board. Defendants are getting the raw end of the stick here. I still believe they get the best defense. They get that the leverage that is brought against companies and their officers is too great. I have a slightly different view from the others.
Okay, so we haven't left enough time for me, but we have left enough time for you. So I'm going to pretend I'm a member of the audience and steal one piece of your time and ask one question, and then we'll open up to everybody.
That make it less likely people who have defenses will cave prematurely. So,
plea bargaining, but because obstruction really matters. And if that's the case, we'll concede that there are some cases where obstruction is perfectly appropriate, not only brought for purposes of art of force guilty pleas. Would all 3 of the first 3 members of the panel concede that there are some cases where obstruction is perfectly appropriate, not only brought for purposes of plea bargaining, but because obstruction really matters? And if that's the case, what would you do about the current situation? Would you change the statute? Would you change the judges in the sense of the way in which the judges interpret the statute? Or would you change, as I think Mike pointed out, this question of supervision of the line prosecutors through either directives or greater direct supervision from Main Justice? Any of the 3 of you want to comment on that?
I'll take a shot at it, Merrick. First of all, I think Mike hits on an important point, and I tried to touch on it as well in making reference to the exercise of prosecutorial discretion. In general, allowing prosecutors down to the individual level a maximum degree of discretion to decide what should be charged and what an appropriate disposition of a case may be is important for a whole lot of reasons that we don't have time to go into. On the other hand, it is a fundamental principle of fairness that like cases ought to be treated at least somewhat alike. And right now, in the use of this statute and some others, it's my view that there is far too wide a range of the exercise of discretion. So what's required, I don't think, are rules, but greater guidelines, and most importantly, more supervisions. Assistants appropriately so, like you did, I did, Mike did, get hot-blooded about our cases. But the fact of the matter is that sometimes cooler heads do need to prevail. So I think the department needs to institute some guidelines for the use of this statute and hold U.S. attorneys and their supervisors in the field, as well as people in the criminal division, responsible for supervising the proper and appropriate use of the statute.
Mike, you talked about statutory language, the word encouraging, that sort of thing. Would you take that out of the statute, or would you, like George, rely on greater supervision, or what do you think?
I think you could tweak the statute, but I agree with George completely that the much greater problem is in the supervision of the way the statute is used. In the false statement statute, you have a situation across the country. with increasing frequency that people are called either for interviews or to the grand jury 3, 4, 5, 6 times. And the reason is the perjury trap that Jonathan was talking about. So I think the way to address this, and the most effective way to address it, is through guidelines from above.
Jonathan, on the situation in terrorism cases, so after 9/11, a quite publicly announced prosecutorial strategy was sometimes we're going to go after people with lower charges, with false statements, with obstruction, because the acts may have occurred somewhere else, because the actual evidence of the acts was hard to get, but that we did want to, I think they used the word incapacitate, people who would be a threat. Do you think that this is wrong, that there aren't any such people who are actually threats and the cases are all brought only for plea bargaining purposes, or is there something to be said for that strategy?
Well, first of all, I want to note that I wasn't saying that there's no such thing as a valid obstruction charge. I was talking about cases with count proliferation, where you've got a lot of counts and they throw them in. But I do disagree with the policy set up under John Ashcroft in the first administration. I think it for people in the national security field, I'm not just talking about lawyers, I'm also talking about experts in the field, have criticized the policy. It used to be, we did a very good job in this country in nailing terrorist conspiracies. And I think the people seem to think that before the Bush administration, nobody gave really a damn about terrorism, and we didn't do much about it. But there was a policy back then that when someone came up on the radar screen, they were an asset, and you would follow them, and you would try to build a bigger case. And that was the standard principle that still governs in other of our countries of our allies, so that you can nail the bin Ladens, you can find the hub. But what the Ashcroft Justice Department did is they came in and they just took all of the low-lying fruit, including a lot of people that really were not caught up in this. And their policy was basically, we're going to indict them all and let God sort them out. And I think the result is not good for national security, but also I'll point out, this administration has the worst record of in-trial national security cases of any modern administration. It used to be that the Justice Department losing a terrorism case was rare. I mean, it was very rare for the Justice Department to lose it. In terms of major cases, this administration has lost almost as many as it has won. And the reason is they keep on going to these juries who are very sympathetic with implausible, weak cases, and they're being rejected. In places like Idaho, Texas, you're talking about very conservative places where they have totally rejected these cases. I don't think that's good.
Just on the first point, maybe my question was unfair. So, with respect to the addition of obstruction charges, you're not against them if there's not already a piling on of charges. That is, you wouldn't say that an indictment should only contain the substantive counts.
Right. There are cases of obstruction. I think if you've got somebody who's under a subpoena, goes out and shreds material, I don't think anyone's arguing that person shouldn't be indicted. But what I'm saying is you more often see the case where they hit someone with a bunch of terrorism counts or a bunch of criminal counts, and then they throw in these sort of sirens as their backup plan, as a catch-all.
Okay, Steve, now you've got a second shot at all of them. What do you think?
I don't disagree that there are, in fact, I strongly agree that the exercise of discretion has become a much more important phenomenon given the penalty structure that we have. And I think that what George and Mike said is exactly right, that the Department of Justice could do well, I think, if it provided more guidance. And but part of the problem, as I said before, is it is the penalty structure itself. It is way too high, and I think that Jonathan pointed this out, that it's really hard for some people to stand up and make a defense that years before we had federal sentencing guidelines and a lot of the mandatory minimum stuff, that they would have gone to trial. And they, in a number of instances, as he says, they'd be acquitted.
All right, now I think it's a chance for the audience. I think we have about 10 minutes or so. We have a mic over here. Anybody on this side interested in asking a tough, hard-hitting question? Softball? Either, at your choice. I got to get the mic here. He'll come to you.
This is judiciary. In other words, it's not a matter of the sentence being the sentencing provisions being too harsh. It's the latitude at the judicial level for the judge in imposing sentences. In other words, where after a full trial and evidence being adduced and the facts being found by a jury, the judge would ultimately have the discretion to impose a sentence that would be in line with the totality of the circumstances, or is it in fact the mandatory minimum in a nutshell, or the potential for a man-min that really does put the teeth into this?
Let me just take a first crack at that, and I know Steve will want to address this, but I'm sorry Steve regrets his role with the guidelines, because as we sit here and talk about the need for there to be a narrower range of conduct under the discretion that's afforded prosecutors, which is quite broad. The whole reason sentencing guidelines came about was because the exercise of judicial discretion was perceived to be all over the map. And I don't see any reason, in answer to your question, why, if we tried to fix the problem at that end of the process, that history would not repeat itself, and that the very problems we have today with prosecutors exercising an extreme range of judgment would not reflect itself in judges exercising an extreme range of judgment. Judges bring all of the same beliefs or biases, if you wish, and emotions to cases, and as much as prosecutors try to curb the influence of those factors in their decisions, judges do as well, if not more so. But that only goes so far. The purpose of the guidelines, and particularly the way the guidelines are being used now, which is really truly as guidance, it is a way to try to show judges where the two white lines are and keep all of the cases between them.
Let me just say that the sentencing guidelines were one of the worst ideas in the history of criminal justice, and rest in peace. What we need are good judges like Judge Garland, like every judge that sits in the United States.
He has to say that as long as I'm standing here.
The United States District Court for the District of Columbia, who have the great ability to have exercised their discretion correctly.
Well,
You don't want to disagree with that last point, do you?
well, I do, but I wouldn't dare do it. You know, it's a really good question, and I'd like to answer it in two parts. Mandatory minimum sentences have driven the guidelines up to the level they are. They started in '86 when the controlled substance mandatory minimums came in for the first time. And it's put hydraulic pressure on the guidelines to keep going up. But I think there's another factor, and Marek, you've seen this. What happened was, back before there were guidelines, there was this criticism that white-collar offenders got off too leniently. The judges gave them too many breaks because there was no violence. Basically, the fabric of society didn't feel as threatened. People didn't feel their neighborhoods were going downhill because the white-collar stuff occurred behind closed doors. And so the end result was there was a lot of pressure to increase white-collar sentences. And now what we have is we have ridiculous sentences for non-white-collar people matched by ridiculous sentences for white-collar people. And we need to take a look at this system that we have. If you look at Europe and you look at how they sentence people, the maximum sentence you can get for a white-collar crime in most of Europe is 10 years. And they regard that as really a huge sentence. All the literature out there says that if you lock people up for short periods of time, that short, certain sentences are more likely to deter and to be effective, or as likely as longer sentences. What we do is we put people away, in this country for far too long, and because we threaten to do it, we end up with a guilty plea rate of 96%. And in a country that enshrines jury trials, in a country where the jury trial right is found in not only Article 3, but again in the Sixth Amendment to the Constitution, you might think that we'd want people to go to trial. And we do everything possible to discourage it, and there's something wrong with that.
That last part, if I may. May I?
Yes.
Thank you. I agree with, because a lot is being lost, and it's not just ultimate fairness. There's a lot being lost about an adversary system that's no longer adversary, and that is especially true for companies. Companies can't even afford to risk being indicted, let alone going to trial.
Jonathan, in your remarks, you talked a little bit about the relationship between obstruction and the sentencing guidelines. You want to put in here?
Well, I agree with Mike in terms of the sentencing guidelines. I think that they were a terrible mistake. I think even under the current system, what we find with judges is that they really do stay within the guidelines, which I think are way too harsh. And it's very hard to get judges, even in this period, to get them to depart or go below that range. And these are very thoughtful judges. It's just that they still feel that they have to stay within the range. And I think that they're very, very harsh, and they have a distortive effect upon the whole system. I think Steve really said it very well, indeed, that when you're sitting down with someone like Tom Butler or someone who's just first into the system, and they're looking at a count proliferation indictment, with dozens of indictments, and they're looking at 80 years, in some cases 200 years if they're consecutive, and you're looking at the guideline range, I got to tell you, it's very hard for them not to plead because they can't do that to their family. They would essentially, these people having to decide to bankrupt their family and then run the risk of being convicted. And sentencing guidelines, I think, need to be reexamined. I also think that the omnibus provision needs to be reexamined by Congress.
Do we have time for one more? Or let's have somebody on this side gets represented. There's somebody hiding in the corner.
Professor Salzberg, members of Congress are political animals, and they are not going to vote to reduce sentences for criminals, because if they do, they'll get defeated. And if that's true, then which I assume is, then what other solution exists to the problem that you described?
I'm glad you asked me that because I finished my term as chair of the ABA Criminal Justice Section in August, and I have one more chair's column that I have written for the Criminal Justice magazine. And what I urge is, I made a comment there, and I have an urging. My comment was, thank goodness that the three major presidential candidates haven't been talking about crime. Thank God, because every time they do, it's the same thing. It's scare, 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 increase, increase, increase. And so for one of the rare presidential elections, it's been a non-issue. And the reason I think that's a good thing is I believe the next president of the United States, whether it's John McCain, Barack Obama, Hillary Clinton, I don't think it's going to be Bob Barr, but include him there too. Next president of the United States, whoever it is, ought to have a national summit on crime and on the way in which we handle criminal cases in this country. And ought to bring together people from all parts of the spectrum, law enforcement people, people who've been dealing with terrorism cases, and they ought to take a look at how out of control this system has become. And they ought to bring state prosecutors. There are somewhere between 24 and 2,700 elected state prosecutors in this country, and a number of them have adopted innovative programs to reduce crime, reduce the number of victims, and reduce the use of incarceration, and particularly long-term, as a way of dealing with the crime problem. And it's time for the federal government to take a look at how smart some of these local jurisdictions and states have become. And it's time for a president of the United States to take a leadership role. Just so you know, this for me is nonpartisan. For me, one of the worst things that president has ever done to the people who elected him was Bill Clinton, when the Sentencing Commission recommended equalizing the crack cocaine guidelines with the powder cocaine guidelines, and he ordered the Justice Department to oppose that. I mean, the Sentencing Commission was the expert group. It gave political cover to what was an issue that needed to be resolved. It cried out for resolution. And pandering to those people who are frightened of crime. The president basically left things the way they are, so we have this 100-to-1 disparity, which has resulted in an enormous disservice to the African-American community and accounts for a number of the reasons the federal prison population has the racial mix that it does. It's time for a president to take some leadership from day one.
Okay, and with that campaign speech, we'll end. We want to thank you all very much for coming. I think I can speak on behalf of the panelists that we had a good time. I hope you did too. Thank you.